From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court hears a big case that could rein in the administrative state. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. 40 years ago, in 1984, the Supreme Court issued a decision in a case called Chevron v. NRDC, and it obligated judges to defer to the government's interpretation of ambiguous statutes. For a long time now, these regulatory agencies have taken that as an invitation to steer the law toward their policy objectives of their presidents and their administrations with little oversight from the judicial branch. But on Wednesday, the Supreme Court is hearing a pair of cases that could reverse this so-called Chevron deference. Those cases are Loper Bright Enterprises versus Raimondo and Relentless Inc. versus Department of Commerce. Let's start with a clip of oral argument. This is Justice Elena Kagan suggesting to the attorney for Relentless Inc. that reversing Chevron would strip Congress's ability to delegate technical decisions to experts in the administrative agencies.
In cases after all the statutory tools have been used and there remains a gap or an ambiguity, Congress could not decide that it wants people who know something about something to decide the questions that will be left over.
I think that gives away and would take away from courts and give to agencies core judicial interpretive authority. I don't think Congress could do that in the same way that Congress couldn't tell the president how to exercise the veto power or the pardon power. It can't tell courts how to do interpretation and to defer to someone else.
And here is Justice Brett Kavanaugh suggesting that Congress would still have plenty of opportunity, room to delegate.
My understanding is Congress oftentimes will use terms like the agency can regulate reasonable limits or appropriate limits. And that gives, under State Farm, a lot of discretion to the agency to make choices to do what Justice Kagan was talking about, to think about the world as it exists 5 years from now or 10 years from now and not have to worry about going back to Congress. So the question really is for Congress in its drafting choices, I think, what kinds of broad, capacious terms it uses as opposed to using more defined terms or statutory usual kinds of statutory language. Yes, it can't rewrite that. At least that's how I thought Congress could operate in a world where Chevron does not exist.
Alicia, let's start with the facts of this case. What is at stake for the parties that are there before the court? And then second, what is at stake for the rest of us and Americans who are living under this system of governance that we've had now under Chevron deference?
So the stakes in these two cases, they're kind of obscure. And I think maybe the Supreme Court, the justices decide to take these cases for that very reason, that they actually concern a regulation that was imposed under the Trump administration back in February 2020. And they involved the 1976 Magnuson-Stevens Act, which regulates fishery management in federal waters and permits the National Marine Fisheries Service to require vessels to carry federal observers to enforce its regulations. And this was basically in part to prevent overfishing and such. And the two plaintiffs in the different cases that have come up to the Supreme Court, one is this Loper Bright Enterprises, which came up through the D.C. Circuit, and the other is Relentless, the Department of Commerce, which came up through the First Circuit, which oversees or is the New England and Northeast area. In both of the cases, these herring fishermen and fisheries, family-owned, and the vessel operators argue basically that the Commerce Department wrote a rule arrogating its self-authority to require them to pay for federal monitors on these vessels. And the law in itself only requires this in three narrow circumstances, and none of them actually apply. But the way that the Commerce Department, or the National Marine Fisheries Service, which is part of the Commerce Department, actually read this saying, well, the law is kind of open-ended, and therefore, because it's silent on this question on whether we can actually require them to pay for the federal monitors, which, by the way, is not a small cost. It's about $700 a day, or about 20% of the annual profits that they make. Because the law doesn't expressly provide this, well, then it's silent, and therefore that we can mandate it. And this is essentially what they did. And the DC Circuit actually ruled, well, the law is somewhat ambiguous, but because it's silent, we're going to say that, well, the agency's determination and regulation is reasonable. And this is under the two-part Chevron framework that says under the first prong is, well, the courts look to whether language or the text is clear. And if it's clear, well, then that settles it. Under the second part, it's not clear if there's some kind of ambiguity or the judges deem there's an ambiguity, then the courts consider, well, whether the agency's interpretation is reasonable. And in the case of the DC Circuit, they did say that there was an ambiguity in the law, but that it is reasonable. And this is actually what typically happens when the courts look or use a Chevron analysis. They'll say, well, it's ambiguous or silent, but this is reasonable. Or in some cases, they'll do what the First Circuit did, which is say, well, we actually think that's clear and the agency has the authority because it is silent. And during the oral arguments, there was a little bit of confusion how exactly the First Circuit came to the fact that it believed the language of the law was clear. And this is another problem with Chevron, is that often judges use this silence or ambiguity to justify their own policy preferences. And just broadening out, there are literally hundreds of cases because there are so many regulations and administrative agencies are all the time issuing more regulations, interpreting new laws to expand their bailiwick. The Chevron deference really does and can affect every single citizen. I mean, the classic case was the Clean Waters Act regulations that have been going back and forth between administrations, for over 40 years. And the EPA keeps writing a new rule, and the court had been at least required to pay deference to its rules and its interpretations of what is navigable water, which you think would be a pretty clear cut. But you saw, especially going back to, the Obama administrations and this significant nexus test, how it just completely blurred it. And I think that is a case in point of how Chevron deference has kind of gone off the rails. Like when you start to think when regulatory agencies start to define like dry ditches as navigable waters and then get deference from the courts on that, there's a problem here.
To give a bit more background, and this is reading from a 2014 Law Review article on the history of Chevron, it goes into the background of that case and says 3 different programs established by the Clean Air Act require that stationary sources of air pollution like power plants and smelters adopt strict technology-based limitations on emissions. And then it says, yet each of the programs contain a crucial ambiguity about the meaning of source. It is unclear whether this word refers to each apparatus that emits pollution within a plant or whether it refers to the entire plant. And so, Kim, this article is making the argument that Chevron was an accidental landmark precedent, that the justices in that case back in 1984 were trying to figure out whether these Clean Air Act regulations applied whenever a company with a plant was doing work on a single boiler or whatnot within the plant, or whether it applied only to that plant as a whole and the creation of new plants or increased emissions from the plant overall, and that there was not an intent actually to set up a broad system under which administrative agencies would get this kind of deference, which is part of how we end up in a situation now where every new president who is campaigning for office says, on day one of my administration, I'm going to sign an executive order and I'm going to tell all of my agencies to interpret the laws and interpret their own regulations in a 180-degree direction from my predecessor.
Yeah. I mean, there is actually really great history to suggest that this was an accidental doctrine, as it were. I mean, this was an incredibly technical case that the justices were deciding when you had Chevron versus NRDC. And we just had a fascinating piece in the Wall Street Journal by lawyers David Rivkin and Lee Casey, noting that Justice John Paul Stevens, who wrote the Chevron opinion, regarded the decision as ordinary pragmatism. Quote, "When I am so confused, I go with the agency," he told his colleagues in a discussion that they were having about where they were going to fall. So this seemed to be an example of the court just simply being so confused by this technical issue and needing to assemble some sort of majority on a very difficult interpretive question that they ended up making this power, this doctrine that has just gone wild over the years, because all kinds of bad things play into this. What you have happening is you have the Congress, which has increasingly become lazy about its job of spelling out what should and should not happen in a statute. Sometimes, by the way, that's also intentional. Democratic lawmakers increasingly write very vague laws because they want to give the bureaucratic class the ability to run a Mack truck through the wall and come up with their own version of this. Things that Congress isn't brave enough to spell out in statute, they can leave to the administrative state to do their dirty work on their behalf. You have an administrative state that's become increasingly willing to take up that rope and have essentially become a governing class in and of itself. And then you have a court that's stuck with this doctrine that, because it is a bit vague, increasingly justices who want to defer to the bureaucratic class will just cite Chevron and move on. And I think, Alicia said that one possibility here is that the court does very narrowly rule on this question of what is at stake and these herring fishermen. But it would be very odd for the court to have taken up what is a pretty narrow question about these fees and these monitors. It seems very likely they have taken this up as part of their continuing goal to essentially put everybody back in their lane, much as they did with the Dobbs decision or West Virginia versus EPA, which dealt with the Clean Air Act, or as they've been doing with gun rights or religious rights, saying, Congress, this is your job. Courts, this is your job. Federalism, the states, this is your job. I'm really hopeful that that is what they are doing, because this is a doctrine that has really turned the governance of the country on its head. And you heard Elena Kagan there saying, well, we need a professional class of experts who decide all this stuff. Congress doesn't know enough. The courts don't know enough. No, actually, the Constitution doesn't have a section devoted to the powers of the executive, of the bureaucratic class. There are different roles for the different stated branches of government, and we've kind of muddied that up with all these powers for a bunch of unelected bureaucrats.